The Supreme Court's opinion advisory that courts cannot set timelines for governors or the president to decide on bills before them, but also that governors can't sit on bills endlessly, will spark off a sharp debate, especially in opposition ruled states which have seen fierce exchanges between the governors and the state governments. The Supreme Court's opinion was in response to the presidential reference raised after the Apex Court's judgment in April, setting a 3-month deadline and ruling that assent was quote-unquote deemed to have been given in cases of bills that were pending before the Tamil Nadu governor. The court's unanimous opinion held that the concept of deemed assent is alien to the constitution and that governors will have to take a decision in reasonable time. If they do not, then judicial review will kick in. But without a clear definition of reasonable time, will it open the doors for more confrontations between governors and state governments? In September, remember, the 5-judge bench headed by Chief Justice of India B.R. Gavai had reserved judgment and made it clear that the centre should not expect the Apex Court to sit idle and powerless if a constitutional authority failed to discharge their duties. Listen in to some of the reactions that came in.
Power under Article 200 and 201 of the Constitution of India is a discretionary power, and the governor is not bound by the advice of the Council of Ministers in the matter of taking decision on a bill.
Suppose governor and the bill withhold பண்றாங்கன்னா உடனே அந்த consultative process with the state government அவங்க ஸ்டார்ட் பண்ணனும் to come to a logical conclusion. அந்த ரொம்ப prolong பண்ணக்கூடாது அப்படினு அவங்க சொல்லிருக்காங்க. ஒரு ரீசனபிள் டைம்ல அந்த கன்சல்டேட்டிவ் process நம்ம முடிக்கணும் கவர்னர் அப்படினு அவங்க சொல்லிருக்காங்க.
Well, so what would be the fallout of this opinion advisory? I'll have a political face-off between the BJP and the DMK in just a bit. But first, noted constitutional expert and senior lawyer at the Supreme Court, Aryaman Sundaram, joins me live. Sir, thanks very much for joining us here on the Southern View. The first question that's been raised is, would this opinion advisory overrule the order setting a 3-month deadline? If yes, does it then open the door for potential abuse of the reasonable time principle as alleged by opposition ruled states?
Look, let me start by saying that this is a very conservative judgment going by the letter of the Constitution and keeping very, very clear the doctrine of separation of powers. If you look at what lies beneath the judgment, it is this. The judgment tries to interpret exactly what the Constitution says, letter of the Constitution. Secondly, the judgment tries to see what is underlying the entire Constitution, which is our separation of powers, the basis of democracy. And thirdly, leaves one caveat, saying there cannot be an undue delay. So the takeaway from this judgment is the court has said they cannot sit in judicial review over the decision of the governor. If a governor does not give assent or the president does not give assent, the bill does not become an act and therefore is not open to challenge. However, the governor must, if he is not giving the assent, immediately return the bill to the House for reconsideration, and then the constitutional framework takes over, because if it's sent to him again, then he has to give his assent, etc. But if he withholds his assent and does that, that's one thing. The problem is the inactivity of not taking any action at all. This is where the Supreme Court, while voicing very clearly during hearings that it cannot be left in limbo, however, in the judgment has said the governor, however, is expected to decide in a reasonable time. And if he does not decide in a reasonable time, the courts have the power of judicial review, which will definitely lead us to a question in future, that when the governor does sit on it for political reasons, the state government will say, look here, the reasonable time has passed, and then it will give rise to new litigation. And in each case, the court has to look into the facts of that particular matter and say whether in this case, the time taken is reasonable or not reasonable. So the question as to whether the time taken is reasonable or not reasonable is something the courts will decide. And if they decide it's not taken in a reasonable time, will direct a timeline in which to give the decision.
Right. So you're making a very nuanced point as far as the letter of the law being taken into consideration. When we say reasonable time, you're also stating that this opinion would mean that reasonable time could depend on a case-to-case basis and there may not be a set deadline. Is that the takeaway that we need to take, that it will be dependent on a case-to-case basis?
What was hoped, I
So
presume,
what
by
does
the
this...
petitioners. Sorry,
what does this do, sir? My first question to you, what does this do to the earlier order giving that 3-month deadline?
Well, I think the court itself made it very clear that this is a answer to a reference by the Supreme Court in its advisory capacity, but this will not in any manner reopen a judgment already passed, which was deciding a list between the state of Tamil Nadu and the governor of Tamil Nadu. That has decided and that will reach its finality, unless, of course, the review is still pending or a curative is still pending, in which case that will be decided. But otherwise, inter partes, this judgment will not in any manner in itself, with nothing more, affect that judgment. The opinion given by the Supreme Court today will not on its own rehorse anything else or any other fresh actions affect the decided issue between the parties. Because as far as that is concerned, that's a concluded issue between the two parties in that case. And so far as Tamil Nadu is concerned, the judgment of the Supreme Court in the Tamil Nadu case continues to hold, even today.
Okay.
It continues to hold.
Right, that's an important point that you made because that has been a point of debate. I'm going to bring up the larger issue with you. The abuse or the alleged abuse of discretionary powers is a major issue that opposition rule states have raised as far as governors is concerned, specifically in the case of bills. Do you believe that it is time that we have a categorical definition of reasonable time, or in legal parlance, is it better to leave it delightfully vague?
No, I do not think it's nice to leave it delightfully vague, but do not forget that all the opposition people who are objecting to this extreme discretion given to the governors when they are in the ruling party at a given time are all in support of this discretion being given to the governor. So it's something which supports whichever party is in power, basically. And that is the entire problem. The fact of the matter is, reasonable time, as far as the Supreme Court is concerned, they say they cannot inject into the Constitution what is not expressly stated in the Constitution. But they say what is inherent in the decision-making process and what is sub silentio there in the Constitution is that such a decision for the purpose of subservience of democracy should be done in a reasonable time. But they've stopped there by saying beyond that we cannot rewrite the Constitution or include words in the Constitution which are not there. So if you want to really bring a time framework on the reasonable time in the opinion of the Supreme Court in this case, and don't forget this was an opinion of the Supreme Court, it's not a decision in a dispute between parties. It's an opinion on a reference for its advice asked by the President under Article 143 of the Constitution. So in the opinion of the Supreme Court, while it should be done in a reasonable time, the reasonable time cannot be stipulated by the court. However, I believe that it is time for Parliament to look up, the legislators to look up and say, look here, this can create a problem on either side of the fence. So let's lay down a timeline for such decision to be taken. Of course, leaving exceptions that in certain cases the timeline need not be adhered to if for various reasons that it's found that in the facts it has to be a longer time. So something like that can only be done through constitutional amendment and not otherwise.
Right. Important point that you've made there. You've really explained the context of this judgment, both in terms of separation of power and in the fact that reasonable time could be defined on a case-by-case basis, and that this does not overrule the 3-month order or the earlier order that was given by the Apex Court. Thanks very much, Mr. Aryaman Sundaram, for joining us here. Joining us also this evening for a quick political face-off, Selam Dharanitharan of the DMK and Siddharth Yadav of the BJP. Selam Dharanitharan, does this opinion allow space for further confrontation? Is it a setback for the DMK, which claimed victory from the earlier verdict?
Absolutely not. The court in itself has said that the governor has only 3 options. One is to give assent, or either send it to governor or send it back to the legislature. And if it's sent to the legislature, resend it, he will have to immediately give an approval. What was the BJP arguing? What was Tushar Mehta, the Advocate General, arguing? Saying that if a governor is withholding, it means the bill is rejected. So the court has clearly said that the governor cannot reject a bill. And they also said, in a democracy, it's the legislature that is supreme. So that puts all the BJP's argument to rest. And more importantly, this is only an opinion given for the questions asked by whom? By the president herself. What was the judgment given on the 8th to the DMK's petition? Is that all the 10 bills which was put in abeyance and then sent to president was deemed to be passed. Because why? This bill was sent back to the governor the second time, and when it was sent to the second time, he sent to the governor, which is constitutionally wrong. So this opinion of the Supreme Court does not set aside that order, and those bills are deemed to be fit.
All right.
When it comes to the 3-month timeline, the court has clearly said the bill will have to be passed as soon as possible. It cannot be inordinately delayed. This debate came even in the Constitutional Assembly when they said, should we set a timeline? They said, no, people are going to occupy.
No, you made your point. I know there is a nuanced legal argument to be there, but there is also a political argument, which is why the legal question has come up. Siddharth Yadav, is it perhaps time for legislators to declare categorically the timeline required or the timeline within which a governor should decide on a bill, whether it is grant assent or return it back, but not sit idle on it?
No, I think this was the main bone of contention which was before the Honorable Supreme Court. And the Honorable Supreme Court adjudicated this issue and has not laid down any timeline. So I think that speaks volumes. If a constitution gives a mandate, and Article 200 and 201 of the Indian Constitution gives that power and discretion to the governors, nobody can rewrite the constitution and say, this is as per our convenience and this is what we feel. The people and the political parties who have been trying to politicize this issue for their own political gains should really look back and understand what the exact issue is. The Honorable Supreme Court, and we welcome the decision of the Honorable Supreme Court, has very clearly said that timelines cannot be fixed. Obviously, if a bill has to be sent, the 3 provisions that either it has to be sent to the president, returned back, those provisions are nothing new. Those are present in the constitution itself. So those are the mandate of the constitution that the governor has to follow. But can timelines be fixed?
Do you believe that this
I think the Honorable Supreme Court has made it very clear.
No, but do you believe, Siddharth, that this opinion of the Supreme Court opens the door for perhaps further confrontations between the governor and state governments, which has reached acrimonious levels in states like Tamil Nadu and Kerala? Isn't that, some would argue, an undermining of the constitutional machinery?
No, I think, and that is why I said that the people in political parties who have been trying to politicize this issue should actually look back and understand what it actually is, because I don't see that there is much of a confrontation except for few political parties who wish to take political gains out of that. And I speak data for that. In past 55 years, 90% of the bills that have been sent to the governors have been cleared within 1 month. Within 1 month. This is the data of our country. Only 20 bills in past 55 years have been held back, not given the assent. If that is the data, what is the confrontation? Why is it that only DMK sees this as an issue? Why is it that they try to make a hill out of a mole? They are trying all of this political drama for no reason. If the constitution gives a discretionary power to the governor, it is our constitutional forefathers who have made this, who have given this power. Does the DMK wants to rewrite the constitution? They want to scrap the constitution away and rewrite their own constitution? This is not how a country would work. The discretionary power is available with the governor. They have time to deliberate upon any issue that comes before them, and upon that deliberation, they have to act upon according to the mandate which is laid down very clearly in the constitution. Now the Supreme Court has even impressed upon it and has sealed this issue.
The atmosphere of political confrontation has been created by the state governments and opposition parties for political advantage. Respond to that.
Yeah, I think there's one party and organization does not believe in the constitution. That is the RSS and the BJP is the point number one. Point number two, the entire confrontation has been that the governor can sit on a bill. If he's withholding on a bill, that bill is annulled. He can reject the bill. The entire argument comes from the 1930s Act when during the British Raj that governors can reject a bill. Now the court has clearly said governor cannot reject a bill. There are only three options. That is the major victory. Now BJP can come and say, oh, it's a victory for us. No, it's preposterous. And the court has also said you can't sit inordinately on a bill. If you are going to sit individual cases, we will review it. By saying in the last 55 years or 70 years that bill has been passed within 1 month, only says one thing. What does it say? It says that until 2014 everything was working very well. And even now, the problem does not happen only in Tamil Nadu. Punjab faced the problem where the bills have been pending for more than 4-5 months or 1 year. In Kerala, there has been problems. In West Bengal, there has been problem. But in BJP rule states, the bills are immediately passed by the governor.
So let me take that to Siddharth Yadav. The point that is being made by Salem Dharnitaran, that problem is there in every opposition rule state.
One more interesting point which is not mentioned is that the court has also said individually, the governor delay a bill. If the individual, one second, sir.
Go ahead, Siddharth.
Individual matters wherein a bill is being inordinately delayed by the governor, it is appreciated.
Should I answer or
let Siddharth respond, Salem Dharnitaran. Go ahead, Siddharth.
If I have to answer, then I'll begin. No, the issue is very clear. What a governor can do with a bill, it is written in the constitution of our country. There's no confusion. The Honorable Supreme Court has reiterated that. Nobody can rewrite the constitution. The DMK probably feels that they can make a new constitution. They can, bypass the constitution.
No, it's wrong.
They can bypass what the constitutional forefathers had set down. But the constitutional forefathers have not laid down a timeline, and that is the subject issue, because they gave that discretionary power to the governors of our country. Because it is not a rubber stamp. One has to understand. They have a role to play. They have a place in our constitution, they have a place in our democracy. If governor has to do application of mind and has to exercise his discretionary power in whether to forward the bill or to return it back or to hold it for whatever manner, the Honorable Supreme Court has very clearly said that we shall not put timelines the same. What the constitution also says.
But at the same time, it is said that the governors cannot sit on a bill for endlessly period of time, and then judicial review will step in. But we leave this conversation right now. Thanks to both of you for joining me. Go ahead, 10 seconds.
See, Ambedkar himself in Constitutional Assembly debate has said
if that window is open, the Honorable Supreme Court would adjudicate.
And the why timeline was not set is because it was assumed that governors will be of high moral value, authority, and then they will abide by the constitution and pass the bill as soon as possible and not delay it. It was not foreseen.
All right, we leave. We leave the conversation at the moment here. We will come back to this debate because this could possibly set the stage for further confrontations. But thanks very much, Salem Dharnitaran and Siddharth Yadav, for joining us now.